The changing and competing priorities of portfolio management associated with the rapidly growing pen portfolio.
Thanks, Zane. If nobody objects, I'll stay seated because I'm effectively going to be telling a story, and my children much prefer it when I'm telling them a story rather than wandering around the room. It just seems to sit better with people. I think one of the things I'd say is that something that Zane read out in my introduction was actually quite telling. I'm actually the first IP counsel for MasterCard outside of the US. And that was 5 years ago. And you think about the global reach of a company like MasterCard, to have everything centralized in the US for 45 years, because we recently celebrated our 50th year in existence, that in itself gives you an indication of the changing priorities and the changing landscape within which we're operating. I'll roll back a little bit to give you some background on where we were and how we've moved on. And as much as that says the views are my own, they are my own. However, the story is very tightly based on where we've come from and where we're going and where we are now. In 2010, MasterCard had 290 patents or pending applications in the US, roughly 150 in Europe, and extremely limited coverage outside of these two regions. Now, when you think about the global footprint of MasterCard, the fact that it's accepted all around the world, admittedly China has been slightly later opening up, but it still has. But South Africa you could go to Brazil, Japan, all these countries, and we only had very limited coverage. So bear in mind the numbers, 290 and 150. As of last year, we had 2,125 pending patent applications or granted patents in the US, and 390 in Europe. We have much bigger coverage in, for example, China, India, LAC, all the large markets. The increase in filings has been almost exponential. In 2011, we made 62 first patent filings. Last year, 549. That's not 549 convention filings, that's 549 first priority filings. So, I think the question that this really begs is why? Why was this sea change in the policy and the approach? And ultimately it comes down to, I think, two things. In 2006, MasterCard moved from being a bank-owned association to a publicly traded company. So you've basically gone from what I would balk at saying, but I'm about to say, a gentleman's club into the real world. I hope to God that never gets back to the board. And also a shift from a banking company to a financial technology company. We were always a technology company. Okay? You think about when you make a payment. You say you're using chip and pin. You put that into the point of sale terminal, cryptographic exchanges, messaging, servers. That's all going on in the background. Contactless, similarly. Cryptographic exchanges going on via an NFC channel. Because it's so ubiquitous, many people don't appreciate the technology that goes behind it. And I would actually include patent examiners in that. If there's any in the room, I do apologise. The other thing I think that changed was the CEO. Ajay Banga, the current CEO, is very much, I hate this word, but I'm still going to use it, visionary about the way he sees the technology driving the transformation in the world and driving transformation in payments. So now I'll move on to touch on the changes that have come about and how those changes have fed into the priorities that we've seen as the portfolio has grown. I mean, remember, we've gone from 250 patent applications and patents in the US to 2,152 in the space of only 5 years. That doesn't come out of nowhere. So I think the most important thing is to actually get the culture embedded in the company. We conduct over 100 outreach and education sessions to our businesses every single year. This is not a go in, one hit, forget about it. You go in, you do it again. It may be a year, maybe 2 years, you go in, you do it again. And not just because there's a turnover of staff. It's primarily to keep that awareness going and to keep driving people forward. Another change, as you can imagine, has been an increase in headcount. In 2012, just before I joined, there were 3 attorneys, 1 paralegal. We're up to 9 attorneys across the world now and 3 paralegals. So, you've done the education. You've been out there. You've spoken to people. You've drummed the message home. That's all well and good. But how do you make them want to file the patent application? What's in it for them? And it may seem a fairly straightforward thing to do, but we've introduced an incentive scheme for inventors, whereby they get payment on filing of an application and also payment on grant of the first patent out of any family. That also drives another good behaviour in that, for example, if you need somebody to execute an assignment document who's left the company prior to the filing of the application, you can dangle the payment in front of them to say you will get paid if you sign the assignment document or the declaration. It all just goes together to drive good behaviour. For the exponential ramp up that we've seen in the past 5 years, the initial factor that was brought in was volume. Get as many applications filed as you can, covering as much as you can, however broad that may be. And unsurprisingly, that has led to a few patent applications being filed that I think one could describe as non-core. There was one that was reported in The Economist, I don't know if anybody saw it, about giving people the option to pay extra for larger airline seats based on their purchase history. So, say you were buying trousers with a 44-inch inside leg. If there was the availability of that, what we call SKU level data, individual item level data in your transaction data, which isn't available to us at the moment, I hasten to add, for privacy concerns. But if it were to be, then next time you went for an airline seat, they could say, oh, okay, you have been buying trousers with a 44-inch inside leg, perhaps you'd like more leg room. And this was seized upon as an idea, almost as a poor patent, a poor patent application. I'm not sure it was a poor idea in terms of an idea, in terms of a patent application. I don't think it was a poor application to file at the time. But what we have done, moving on now, is to ensure greater alignment with the business and the business focus. We've introduced patent committees within the business, where we get senior people from those business units to sit down and use their expertise and their knowledge in their fields to vet those applications. Again, it may seem straightforward, but the number of companies that don't do this and actually just file and file because it's a patent application and we need patent applications to hit our numbers is actually quite frightening. And indeed, we were there some years ago. So what we have is MasterCard advisors who go into banks and produce reports and do data analysis and do some very complex data analysis. We have a committee in there. We've had that for about 2 years. That's working very well. That's cutting down on the peripherally relevant applications. And we've also introduced one, we are introducing one in our digital payments and labs function, which was the MasterCard labs that Zane mentioned in my introduction. I think another area that I mentioned was the geographic spread. Now, how do you encourage a geographic spread in your portfolio? If the business has control of the money for funding applications, the business is typically looking at its budget on a year-to-year basis. It doesn't have the long-term vision in terms of the importance of IP and that protection. So what we did was we took control of budgetary requirements for overseas filings. So we go to the business now and we say, where are the relevant countries that this could be filed in? Which jurisdictions are you using this in? Is this relevant for a European market? Or indeed, speaking to Delano's point, if we get something that is, for example, the airline seat patent application, somebody will come to us and say, I want to file this in Europe, and our response will be, don't bother, it won't get granted. Something as simple as that shows cost restraint, shows control. It shows that you're in charge of your own destiny, essentially. If I move on to costs, I think from the numbers that I've spoken about, the costs have increased dramatically. I mean, that's just self-evident from the numbers. So, in any organisation, but particularly in a large corporate, it's essential to manage your own destiny by taking control of those costs and managing them in an intelligent way, rather than relying on somebody in senior management to come knocking on your door and telling you to do it. So what we've done is we've introduced fixed fee schedules. We've introduced annuity reviews. In terms of the fixed fee schedules, what we've also done is make sure that they're not punishing, because we don't want to compromise quality. The whole thing about the patent committees and making the patent applications we file much more business relevant is to maintain that quality and that business relevance. If you start hitting your outside counsel with $2,000 for drafting and filing an application in the US, there's the old adage, isn't it? If you pay peanuts, you get monkeys. And that's not what we're looking for. We're looking to maintain good quality. We have to. Dropping non-core assets at various points in their life. I'm sure everybody knows that IBM are the world's biggest patent filer. But they don't hold the biggest portfolio Samsung do. And the reason for that is that IBM drop an awful lot of cases after their first US annuity post-grant. So they get the cachet of being the world's biggest filer, but they don't incur the annuity charges on non-core assets. So just that sort of intelligence and that intelligent way of thinking can allow you to control your own destiny in the corporate environment. And I think the last point that I'd like to make in terms of really talking about the corporate environment is, what's the return on investment? As our costs have rocketed, we've gone from being a small expense in the law department, where to an extent you can sail under the radar. You do what you do, and that's fine. But as soon as the costs rocket and you become an appreciable expense, senior management, quite rightly in my opinion, start asking questions. Where's the value in this? What's our return in investment? How can you justify going from, I'm plucking figures out of the air, 1 million a year to 25 million a year in such a short space of time? What are we getting back for our money? So there's a number of ways of looking at return on investment. Is it direct licensing revenue? Is it the value that those assets underpin? And that's a really difficult thing to analyse, and we have brought in outside consultants to help us with that. And the outside consultants actually did some work on one of our portfolios and came to the conclusion that it was generating a 300% return on investment in terms of the value of the business that it underpinned. That's an easy number to take to the CFO. You can go to the Chief Financial Officer and say, we paid however many million for it. The value that we're getting out of the business is 3 times that. That's an easy win to deliver to somebody in finance. That's what they want to hear. That's the language they speak. So it's really a question at this point for us in terms of monetization, is determining what the best balance is between licensing and that underpinning of core assets. And that will vary for every individual company. But it's something to be aware of, that if somebody says, where's my return on investment? You don't just go, oh, I need to license. There's creative ways of showing true value, monetary value, that CFOs and finance people can see and appreciate. One very final point is around acquisitions. Over the past 5 years, we've made a large number of acquisitions. Some of them actually predicated on the IP those companies hold. Some predicated on synergistic fits with the rest of the business. But I think what's important is to look for holes in the acquired portfolio. Because again, not having done much acquisition previously and now suddenly ramping up the acquisition, this is another priority that you have to look at. You have to get into these companies early during the integration phase to inculcate the culture that we have internally. You can't just expect acquired companies to adopt the culture around IP that the parent company has. You have to get in, you have to work hard, you have to go and do even more of these presentations. So you need to breed that culture of IP awareness and the importance of IP to the overall company. So in summary, we've gone through a journey where our priorities have been expansion, quality, and monetization. The expansion phase is very much, I think, over at this point. There will possibly nominal increases in our filings, but we're kind of settled at the level we are. In terms of the quality, that is going to be an ongoing focus for us permanently, as will the monetization. But we couldn't get to those 2 steps without the initial expansion. So I hope that's given you some sort of idea of the journey that we've been on and that we continue to be on. We found it very transformational in terms of the processes we've had to adopt, even around fixed fee billing, the expansion of docketing systems. All these sort of things need to be taken into consideration, and those costs need to be taken into consideration when you're expanding a portfolio that dramatically. And with that, I'd like to finish, and if anyone has any questions.
So I'll open the floor for any questions from the audience. Right, gentleman over there.
Yes, thank you. Question for Mr. Kim. Can you tell us since it is your opinion, what your opinion is about the research exemption in the US? I mean, how much time before the final expiry of the patent can the generic start with research towards bringing their generic product to the market?
Yeah, so that's actually a very interesting question. I don't believe that there's actually a time limit specified in terms of when you can begin conducting experiments in support of your generics application. It's actually limited more by the subject matter of what you're doing. So, if I understand your question correctly, you're asking, let's say before the expiration of the innovator's patent.
Maybe refine a bit. What would be considered still patent infringement, research or not?
Oh well, so the courts have gone back and forth regarding this, and I think there's a slew of case law. But I think the bright line rule is that so long as the research activity that you're conducting is reasonably related to information that you're gathering in support of an application, like say a generics application, then you're covered under the exemption. So if you know, you have to understand, like as you point out, that the original intent of this was to make sure that generic manufacturers were not barred from conducting trials and whatever studies they needed to do in advance of the generics approval. So that kind of activity, I think there's probably very little ambiguity that those would be protected by the exemption. Mm-hmm. So I think where it gets a little bit more ambiguous is where you know, the patent actually relates not to the drug, but it actually relates to an underlying assay or a technology. That it's less clear whether that's covered by the research exemption. Yeah.
Thank you.
Any other questions?
Question for Mr. Kim as well. How would you expect the recent decision from the Supreme Court about patent exhaustion impacting the patent situation in the pharma industry?
So that's actually a very interesting question. So I think we've looked at a couple of scenarios where there might be impact. So as you might know, that you know there's sometimes cases where a first drug is originally approved, and then the second drug is actually a combination of drug A and drug B. So we wondered if that might actually be a scenario in which patent exhaustion might come into play. So yeah, I must say that you caught me a little bit off guard, because we're aware of the issues and we have started to analyze it, but I think at our last analysis we thought that it would have to be under very extraordinary circumstances where that might actually be problematic. So, just caution that it's an incomplete analysis. So, yeah, watch this space. Yeah.
All right. Okay.
This is for Sean. Understanding and controlling the cost of developing a patent portfolio is really hard. If I was a director at MasterCard, I would want to know, why are we doing anything else? If you get a 300% return, shouldn't this be our entire business?
I don't think being a non-practicing entity really appeals to MasterCard. I think they like that. I mean, I think you need the underlying business. What that 300% return on investment refers to is actually the value of our core business that is underpinned by that portfolio. So that's the value of the business that that particular portfolio protects. So it's not an actual incoming monetary value. That's what I was saying. There's two ways of looking at it. You can either look at it in terms of incoming revenues, or you can look at the revenues from the core business that are underpinned and protected. I once had somebody who did patent valuation say to me, what would you like the number to be? I can produce any number of defensible values for it. You know, do you want it for acquisition? Do you want it to sell? Do you want it for tax purposes? All of which are defensible. But this was a fairly neutral analysis of that portfolio. So that's what it refers to. It doesn't actually refer to incoming value. It refers monetary value. It's
Because it's hard. If you expect to pay $12,000 for a patent application and you expect it's going to be worth $100 million, this is capitalism. I mean,
there's not a lot of those out there, unfortunately. Those patents out there.
thank you.
Do we still have enough time? Okay, so that concludes our session for this panel. Let's give them a round of applause. And I have to hand out some plaques.
We shall continue with our next session, that is session 3. And this session will focus on open innovation. Does IP get in the way? Our moderator for this session is Ile Yilmaz, partner at ELIG, attorney at law. And the speakers are Sophie Christines, corporate